Many clients come to us after an accident and they're worried because they've got a pre-existing condition and they want to know, hey, is this going to affect my case? And the answer is maybe, but it doesn't have to. Florida and most jurisdictions have what's called the 𝘊𝗟 plaintiff rule. And that means you take the plaintiff as you find them. So if you have a pre-existing condition and that condition suffers a permanent aggravation, okay, that needs more care, you're entitled to claim that aggravation as a part of your accident claim. So, a typical example, and we've had this happen, where is a client comes to us who's had a prior knee surgery 5 or 10 years ago, has been told that when they're 70, they're probably going to need a knee replacement. They have a car accident and their knee hits the dashboard. Now all of a sudden the knee blows up, it hurts again, hasn't hurt in a while, it's bothering them. They go back to their old surgeon and the old surgeon says, well, I was hoping you could make it to 70, but you need that knee replacement now because you hit your knee on the car, on the dashboard in the accident. So that case, to me, is a clear-cut case. The defendant has to pay for that. That's a classic example of a permanent aggravation that resulted in the need for a greater level of care. And that's it. That's really the question. What was the level of care needed before the accident? And what's the level of care needed after the accident? If you can define those two things, that'll tell you whether or not you've had a permanent aggravation. It's really a question for your doctor, but it's going to be obvious in the medical records. You're going to look back. Was there a need for surgery? Yes, maybe way down the road, but that need is now immediate, okay? And that is a significant change in the level of care. So don't let the fact that you've got a pre-existing condition dissuade you from bringing a claim. You should absolutely do it if you've got that change in the level of care and you need more care.